See a problem?
Mr. Justice Mkhapula.
Good morning. Thank you, Acting Deputy Chief
You have
Justice.
more than one device on there. Please switch one of them off. Yes.
Good morning. Thank you, Acting Deputy Chief Justice. I am the Registrar Clerk for this hearing. Justices of the Constitutional Court or Counsel are online.
And are all my colleagues also online?
Yes, Acting Deputy Chief Justice.
Thank you very much. You may call the case, please.
I call the matter of Minister of Justice and Correctional Services and others and Mbalenhle Sidney Ntuli for hearing. Counsel are now invited to place themselves on record. Please note that this hearing is being recorded.
Acting Deputy Chief Justice and Justices, my name is Fana Nalani, and I appear together with my learned colleague, Ms. Mota, MOT.
Thank you. Oh, thank you, Mr. Nalani.
Acting Deputy Chief Justice, members of the court, I, Adila Hassan, appear together with my learned friend, Mr. Brickhill, for the respondent.
Thank you, Ms. Hassan.
Acting Deputy Chief Justice, Justices, I'm Nick Ferreira, and I appear together with Mr. Salu Kazana for the amicus curiae.
Thank you, Mr. Ferreira. Yes, Mr. Nalani.
Thank you, Acting Deputy Chief Justice. This matter revolves around the rights of an inmate to pursue further education within the precinct of a correctional center. The crisp issue is whether an inmate should be allowed to have in their possession and use a laptop or a personal computer in their cell for purposes of pursuing computer-based education. And the issue is whether if one restricts that use or completely prohibits it, whether that is an interference with the right to further education. Our submissions are as follows. We'll submit in the first instance that the prohibition does not restrict the right to pursue further education as enshrined in Section 29(1)(b) of the Constitution. And secondly, we'll submit that if in fact the prohibition does restrict that right, that the prohibition is reasonable and justifiable in terms of Section 36 of the Constitution. We will submit that in the justification, there is sufficient evidence before the court to support the views and the motivation of the government to impose the restriction, because the possession of a computer in the cell, whether single cell or communal cell, is a security risk, both from a software or cyber view or from a physical view. Would submit that if the evidence that the department and the applicants have submitted is deemed not to be sufficient, that should not be the end of the inquiry, because the court should then say, we are dealing here with a policy, and therefore we should apply the standards which this court have laid out in the case Minister of Home Affairs versus National Institute for Crime Prevention and reintegration of offenders, commonly known as NICRO, which at paragraph 36 of the judgment, the last part says, a failure to place such information before the court or to spell out the reasons for the limitation may be fatal to the justification claim. There may, however, be cases where, despite the absence of such information on the record, a court is nonetheless able to uphold a claim of justification based on common sense and judicial knowledge. And if we may underline that last part of judicial knowledge, of course, judicial knowledge can also be edified by counsel in submissions, but basically it is an experiential issue and a matter of common sense, and would submit that the court should then view it in that fashion. As far as common sense and the practical common sense approach is concerned, I stand in a slightly unique position today because I have sympathy for all the parties. Mr. Ntuli, I sympathize with my client, the department. I also sympathize with the Judicial Inspectorate. In my other life, I was a political prisoner, and I also studied in prison. So I understand the value of further education, even in a prison setting. And the value of this policy is so important because in our times, it was very difficult to access even reading material. So I would say that the department and the government have made much strides to make sure that those who are imprisoned are able to access further education. In our times, I had to go on a hunger strike just to get reading material. But Mr. Ntuli is in a very privileged position. But I empathize with him because I know what it takes to pursue further education in prison. But I also empathize with my former jailers, my client, because now that I'm outside the system and looking back, I appreciate the difficulties which the correctional services have to keep prisoners safe, to secure them, and to make sure that the system works, not only for the benefit of the inmates, but for the benefit of society as a whole. It takes a lot to take care of hundreds of offenders and make sure that they stay on the narrow and straight path. At the time when I was there, of course, it looked terrible. It was terrible. But I now appreciate, for instance, when I wanted to study, in the facilities where I was held, there were two types of cells, really. There was a single cell or the communal cell. And the only way in which you could be given space to study was in a single cell, but the single cell was about 8 or so. So the physicality of the institution was not able to cater for a person who wanted to further their studies. And so those physicalities and realities must be kept in mind. And that is why the right to further education must be viewed within those limitations and the security concerns of the department. The Judicial Inspectorate, they play a very important role, and I was a beneficiary of that. They're not called the Judicial Inspectorate then, but a judge who came to visit and made sure that I had a place to sit and take my exams. They play a very important role observing what happens in prison. And my faith in the justice system was restored a little bit. Now, if we may begin with the points, what really is the content of the section 29(1)(b) right that is being asserted here? The SCA judgment makes it clear that what is not in issue here is the positive part. In other words, the state is not obliged to give all inmates who may wish to pursue further education, they don't need to give them laptops. But we'll say in this case, the policy in its thrust, in its entire thrust, makes it possible for inmates like Mr. Ntuli to pursue further education. There is a center where computers are stored, even personal computers, but they are only accessed at specific times. And we'll submit that it is reasonable for the restriction of time to be had in the prison setting. It is not unreasonable to say those who have personal computers can only access them at a specified location and at specified times. The point of departure of the SCA judgment is that a prisoner must have the computer at all times, so that in case he wants to study at times when he doesn't need to be out of the cell, he must be in a position to do so. Our submission is that the state has gone far enough. It has not prohibited anyone not to study, even if they are studying a computer-based program. So as a point of departure, the state has provided the means, resources to enable people like Mr. Ntuli and other inmates to realize a Section 29(1)B rights. So we say as a matter of departure, that right is there, it has been provided, and Mr. Ntuli has been able to fulfill and enjoy that right. The emphasis really is on access to the right. The issue is not about the personal computer per se. The personal computer is a means of enjoying and accessing that right. But we're saying there's no prohibition. Mr. Ntuli and other inmates are able to exercise their Section 29(1)B rights, as he has done, and he has done well in his studies. If the court would say to us, we don't agree with you, there is a restriction on the right, our submission is that the restriction is justified. Security is a big concern, and that is why people are in prison, so that they can be secured and the community as well may be secure. One of the criticisms about the security point or defense is that there's been lack of evidence or insufficient evidence to justify the limitation and invasion of the right. Our submission is the following. Security is a matter which should be left to the devices and expertise of the prison authorities. I made a submission in the SCA that, for instance, a warder might decide that a particular prisoner must not have a toothbrush in their cell, because even a toothbrush is potentially dangerous. But that assessment must be left with the prison authorities. They work with the system. They know what the system entails. The applicants are saying that there are risks inherent in the possession of electronic device. And the emphasis is not on electronic devices, restriction on their use within the correctional facility. A computer is one of the devices, of electronic devices, which can be used. And the risk, as the department has said, is that there is an influx of smuggled cell phones which get into the system. And the risk is that somebody with a computer, even if the computer has got no modem, they may be able to hotspot with the cell phone and access the internet. Well, one might say, well, there's been no incidents, recorded incidents, which the department has been able to document and say, so many people have hotspotted, so many people have done this. But it's a risk which exists. It is there. And one cannot say, you must have 100 breaches of security. You must get there first. You must document them. And once you've got hundreds of them, you must come back to court and tell us that there is evidence that, in fact, the breach is there. Risk management means you minimize even the possibility of the risk occurring. Because once the security occurs, then it will be too late. Jigsaw has done a fantastic job recently, as we read in the media, that there was a security breach in one of the privately managed and run prisons. There's a matter of public knowledge, and that one notorious inmate managed to escape, and he used, while he was there, he used a laptop to do transactions. And so that risk is there as a matter of practice, as a matter of common sense. When these privately managed prisons and contracts were negotiated, I was lucky enough to be involved in those negotiations. And one of the risks that was very, very contentious, a subject matter, was escapes. In the contract had to make provision that what if someone escapes?
Mr. Mbalenhle, I know it's your protected time, but when you opened, you gave evidence. Now again, you are giving evidence. I stopped myself and said we'll engage you on that when the time for questions comes. But I'm just thinking, must we let you continue testifying from the bar?
Just Malanga, it's when we opened, we said that one of the things that, because we're dealing with policy matters, there are some matters which are.
I've stopped the clock. I'll give you the time. Yeah, yes, continue.
As a culprit. So when you provide risk management processes, like prohibiting the use of cell phones or electronic devices, including personal computers.
Let me just say, I've made my point. Continue with your submissions.
Yes.
So I'll give you 1 minute more.
Yes, thanks. So it is a matter of, in the public domain, which would submit that without necessarily accepting every report that comes, but the public, what is in the public domain is that somebody used a cell phone, accessed or was able to use a computer in the room, in the cell, in the prison. And then this is one of the most secure prisons, privately run prisons in the countries, because the DCS prisons are said to be porous and people escape. But the point of the matter is that even in the DCS setting, the aim is to manage the risk and not to interfere with the constitutional rights of inmates. And that is the very same purpose why it is justifiable to restrict the use of personal computers in cells. One other serious and obvious risk is the physical use of a computer, personal computer. One, you need a charger. You need to be able to charge it. And a charging cord is a dangerous weapon which can be used, especially in a communal cell. In a communal cell, it can be used as a weapon to strangle somebody or to attack them. Even the physical computer itself, prisoners get into fights for all sorts of things. He gets into a fight, he takes the computer and he hits Mr. Ntuli on the head and smashes his head. Those are serious security concerns which a correction facilities manager, like the applicants, have to take into account. And of course, I've mentioned the issue of cyber risk. And that is a justifiable way in which the the department has proceeded in order to limit the rights if the court is not with us, that there's no limitation at all. And so would submit that the judgment of the SCA should not be, well, it should be reversed. The order which the SCA gave was that, one, the policy is unconstitutional insofar as it restricts the use of personal computers in cells. And the order reads in cells. So in other words, from now onwards, in any cell, public or communal or single, a prisoner or inmate can use the personal computer. And the order also says that the department must revise the policy in conjunction with other stakeholders. The difficulty with the judgment there is that as a departure point, while it encourages the stakeholders to revise the policy, the finding is that the prohibition is unconstitutional and unlawful. So therefore, go and fix the policy, but as a departure point, the prohibition is unconstitutional and unlawful. And so we would say it should not, the applicants must succeed in reversing the SCA judgment because the prohibition is justified. And even if the court were to say, go and re-look at the policy, the re-looking must be open-ended. It mustn't have a departure and end point. It can say, the court could say, DCS, go and re-look at the policy without prescribing that the outcome must be that the prohibition is unlawful to start with. And that would be a sensible way if the court were to agree that that the policy needs to be looked at all, which we submit. It's not, it should not be looked at. The other issue that we dealt with on the separation of powers. And our view is that the SCA reached a bit too far by prescribing the nitty-gritty of how, in a way, a correctional services must be run. It went too far. The business of running a prison or a correctional center should be left to those who have got the expertise, the means, the resources, and the mandate to do that. A prison official should have the authority to say, it is against the security of a prison for an inmate to possess a personal computer. That is the function of the executive. As long as in this case, the rights of the inmates to further their education has not only been allowed, but it has been provided for in physicality, in providing the means, the computers, the space where the computers can be accessed. And so the state has done as far as they need to do. The other issue which the court, the SCA, seem to have been concerned about is the idle time. They say, well, while a prisoner is locked up in the cell like Mr. Ntuli, who can't go in and out, he could be using that idle time to study. But our point of departure is that he's got access to the right anyway. The right is not limited or denied. It is simply being regulated. And therefore, One other important point is that Mr. Ntuli has got access to reading material. He can go to the computer hub, print out the notes that he requires. Even though he's doing data processing, computer processing, one needs notes. So he's got access to the notes so that when he goes out to the computer hub, he's able to practice and experiment with the use of a keyboard and all that. But he's got access to the material, and which is one of the big elements of the right to further education, which is that you must have access to reading material. That part is not restricted. It is simply the personal computer which poses a risk. And even the affidavits of the officials of the department who search these prisoners, they show that smuggling of contraband is rife, and so the risk is there. And the SCA says, well, once cell phones have been smuggled into the prison facility, allowing a prisoner, an inmate, to use a laptop does not add to the risk anyway. It does not incrementally affect the risk. But we say, no, it does. You cannot exclude the possibility of smuggling of cell phones, not necessarily by the prisoner, but by their fellow prisoners as well. And so you are in a risk situation, and you can't say, well, the situation is risky enough. So if you bring the laptop, you don't make any difference because the risk is there. The additional risk that a computer used together with a cell phone can do is incremental, and one can't throw oil into the fire and say, well, the place is burning, let's add more fuel. So we'll submit that issue. The court should not allow that. The prohibition should be done away with simply because the risk is there anyway. We say the cell phone, the personal computers will add and exacerbate the risk in that you can do cyber security crimes and other risky situations. I'm about to my note here is the residuum principle, but we agree with the SCA that pre-constitution, the residuum principle prevailed, but post-constitution, the residuum principle has now been concretized in the sense that even an inmate enjoys all the rights that are there in the Constitution, subject only to reasonable justification. So we submit that in this case, there's no restriction. Secondly, if there is, the restriction is reasonable and justifiable in an open democratic society. And we submit that the appeal should succeed. We're not asking for costs. This is a constitutional matter. Let me just see around the room with my colleagues if there's any other point. Justices, those are our submissions. Thank you.
Thank you, Mr. Nalane. The applicants, and if I'm not mistaken, Mr. Ntuli, proceed from the premise that a government policy like the one we have here is a law of general application for purposes of Section 36(1) of the Constitution. I'm not altogether sure in my mind that that question is as easy as all that. I'm thinking, for example, of the Hugo or Hugo judgment in this court. I don't think the majority judgment by Justice Goldstone in that matter grappled with the issue as such. And there, what was at issue was what's called a presidential act, but act not denoting an act of parliament, but being the means that the president will make certain types of official announcements, as it were. And this one concerned the release of certain categories of, or the remission of the sentences of certain categories of inmates. As I say, I don't recall that Justice Goldstone for the majority grappled with the question whether the Presidential Act was a law of general application. But minority judgments by Krikla J and Mukhoro J did. And the two justices differed as to whether the Presidential Act constituted a law of general application. But on what basis would you say government policy is a law of general application for Section 36(1) to find application?
DCJ, one of the issues that arose in the SCA was slightly along those lines as well, whether or not there was power to even issue the policies. And I think how that was resolved was that the Correctional Services Act itself gives the commissioner some powers, including making regulations or orders for the proper governance and running of prisons. So if he says all prisoners, irrespective of which prison you are in, what class, but you're an inmate, the general applicability would be limited, of course, to a community, which is the prisoners, but it applies to them generally. So I suppose this is how we view it, that it is an instrument of power, legal power, statutory power, ancillary power, which the commissioner issued by virtue of his position and power in terms of an act of parliament and his position.
So any subordinate legislation is a law of general. I understand the application generally, but I'm not so sure about it then becoming a law of general application for purposes of Section 36(1). Do you, for example, say that the Uniform Rules of Court are a law of general application for purposes of Section 36(1)? Are regulations made by a minister a law of general application for purposes of Section 36(1)?
Justice, I think our submission would be that law must be viewed in its generality. It might be the Constitution, it might even be common law, it's still law. So any law which applies across the board to even a class of people, it is a law. And if it serves to restrict...
Law, yes, definitely, yeah. But I'll leave it at that. But I think the subject is more complex than the way you and Ms. Hassim have addressed it. But I will leave it at that.
But one last way on it, it would not be too bad for the applicants if it is not a law of general application, because then it will not be susceptible to the type of attacks that. So we're not quibbling with that part. We don't hold too strongly that it is a law of general application.
It actually works in your favor if it is. No, it doesn't. Because once it limits a right, then that's the end of the case for you. You are in trouble. You don't proceed to justification. So perhaps that's why you would want it to fall under 36(1).
Thank you,
Yeah.
Justice.
Anything else on that, or should I move on?
You can move on, DCJ.
Thank you. Mr. Ntuli says that he is locked up for 17 hours, 45 minutes, which means that he is then left with 6 hours, 15 minutes. I hope my sums are correct. During the 6 hours, 15 minutes, he must exercise, eat all his 3 meals, and then be able to also use his computer at the hub. Does that, at an objective level, does that leave him with enough time to use his computer optimally for purposes of education?
DCJ, that applies to all the prisoners, even those who, and it's a function of the regime that applies in prison, that there must be certain restrictions, definitely. There are certain hours, because the system takes people to man and manage it. And so one must take into account the human resources that are there, but also the fact that, as the Tukwane judgment says, you are in a restricted situation. Your rights, your ability to enjoy your rights are necessarily limited, because there must be times that places get locked up and you go and serve your time. And as we emphasize, the issue is not really about restricting his rights. The main consideration is security. And as we all know, even when you go, even in a normal university, you must manage your time. There are times for lectures, you go to the lectures. There's time, the library closes at some time. So it is something inherent in the business of studying that. And one of the things about studying is that it induces in you some discipline that you must submit things on time, and because times open and close, lectures start and they close. And so it is not an untoward restriction on his right to pursue further education. Thank you, DCJ.
Thank you, Mr. Nalani. Colleagues?
DCJ, may I follow up?
Yes, DCJ, okay. Go ahead.
Thank you, Justice Siki. This aspect that the acting DCJ has broached with you also concerns me. I mean, that passage is found in paragraph 27, page 504, volume 6 of the record. That's where Justice Unterhalter's judgment is to be found on behalf of the court. Now, the judge finds that the question whether it's a law of general application is resolved through regard to section 134(2) of the Act. And he says, he holds that the power of the National Commission to issue orders is a species of delegated legislative action. And he finds that the policy is such an order falling within the residual power conferred by section 134(2) PP, and thus constitutes a law of general application. Now, I find that problematic for the same reason that the ADCJ has broached with you. I mean, if one brings policy under that wide umbrella, it does mean that all policy would form delegated legislation and would therefore be a law of general application. I can still understand the regulations, because regulations are made under the Act. But policy does go very far. And I wonder if you thought about perhaps expanding your answer to the ADCJ, or if you want to stay with that explanation, because I do find it challenging to accept that all policy is delegated legislation and therefore a law of general application for purposes of Section 36 of the Constitution.
Justice Majid, in the context of a commissioner of correctional services who must manage a number of facilities spread all over the country and the inmates who reside there, and he wants to change one thing, perhaps all prisons, that in all facilities, and I'm just making a wild example, no doors must be opened before 6 o'clock. And he issues a directive or a policy or an instruction across the board. All heads of various prisons spread across the country will then have to follow that directive or policy statement, because the commissioner has the power to issue orders and to manage the entire system. And he's not doing that on the whim, just because he likes it. He would need statutory, he would need lawful basis to do that. And he does that in his capacity as a commissioner who is widely vested with the powers to manage the facilities lawfully. So we would submit that even if whatever one calls it, a policy, a directive, or an order, it's a matter of nomenclature. But what he says goes. It will bind everybody in those facilities. And if anybody opens the door at 7 o'clock or at 5 o'clock, they could be liable to be disciplined, because the commissioner has issued a lawful order. And so we would still submit that it does permeate into the realm of a law of general application.
So in summary, you support the SCA approach in paragraph 27. Is that what you say?
Indeed.
You support that approach?
Yes, we support that approach.
Now the SCA held that the basis of the policy's justification was twofold. The SCA said, firstly, you say there is access to a computer hub or a computer center. That's the first justification. And secondly, the security issue, the cell phone issue. Do you accept that was the sum total of your justification? Because I didn't hear you add anything this morning. You accept that?
We accept. I think the only nuance on security is most of the debate was about the cyber part, software. Yes. But we also emphasize the purely physical security. And I remember in the SCA, Justice Matojana asked the question. He says, but isn't the charging cable itself a potentially risky item that would allow in a cell? So we want to emphasize the physicality, particularly in a communal cell. Yes. Somebody can use it to strangle another one, or even the physical laptop. It can be used as a weapon.
Yes, but the point that Justice Matlanga made with you earlier is exactly the point about the first justification. I mean, here is a man who only has 6 hours and 15 minutes available to do all of those things mentioned. What purpose does it serve? What rational purpose does it serve to say to him, well, you must access your computer at the computer center? Particularly, and I emphasize this, particularly where the computer is not only the means to study, but it's the object. He does data processing, which, as we know, means he must study the computer, its hardware, its software, and so on. So on what basis what purpose does it serve for purposes of rehabilitation and all the other objects of sentencing to have this man sit for 6 hours and 15 minutes, have to do all those other things and also do the computer work not in his cell but in a computer center? I don't understand it.
Yeah,
It seems grossly irrational to me.
Justice Majid, it is not irrational. The department is saying, if you move the hub, as it were, you move the hub into the cell, that creates a security risk. So it is not so much the hours that he has that he can work on the computer, the hardware and the software. The additional part, and this is where we ask him for, it's a balancing of values and interests. The department says, we will allow you, we'll encourage you, the policy encourages you. We'll even create a hub where you can go and work and study. The risk is that if we bring the hub into the cell, it's got its own additional risks. And that's where the commissioner then draws the line to say, we cannot allow these electronic devices into the cell. Thank you, Justice.
Then just on before I move to remedy, just on the cell phones, it seems to me that the department has a problem with illegal cell phones in the prisons. Surely you should address that problem and not make a general policy regarding laptops because you're concerned about cell phones.
The concern is about electronic devices. And a computer falls into that.
Can you answer the direct question, please, Mr. Nalani? I hear you about electronic devices, but let's be more specific. Your problem seems to be with illegal cell phones in the cells. Once a prisoner has a cell phone in the cell, he or she has access to the internet already. So it seems to me you want to swat a laptop, with a sledgehammer because your problem is cell phones, not laptops.
The risk is, well, it's not possible to eliminate the risk of illegal and smuggled cell phones. With even the best efforts in mind. And so if a solution can be found, which at the current moment, it is not solvable, the risk remains and it must be managed in the best way that the department can, and how it has chosen to manage it that way. And I have a note here from my colleague that the computer has a far wider access than can be done on a cell phone. More data, more legroom to hack, to compute, to commit cybercrime. So even though at this stage we're talking about cell phones, and I know the order says you must use the computer without a modem, but with modern technology, well, sitting here, I'm not sure, and the department says, even without a modem, there is a possibility that one possessing a computer might be able to commit some cybercrime or breach some security. So yes, the illegal cell phones are a factor, but the fact that the computer itself is an electronic device, that in itself creates the cyber risk. Thank you.
Mr. Nalani, we all know that the computer without a modem or fiber or Wi-Fi link cannot access the internet, and without the internet, I don't see how you can commit cybercrime. But let me move on to remedy, because I think you're just repeating what you said earlier. The SCA made an order declaring the policy inconsistent with the Constitution, but it also made an order that in liaison with JCIS, a policy should be redeveloped over 12 months. That's the first part of my question. If we are not with you, do you have any qualms about that part of the order of the policy being developed over a period of 12 months in particular? And secondly, the SCA also granted Mr. Ntuli interim relief. Secondly, do you have any qualms, if we're not with you, about that interim relief that the SCA had granted? And if so, what are your objections?
We have no qualms with the first part of a 12-month period within which the department may have to relook at the policy in conjunction with JICS. That part we don't have any problem if the court is not with us. The interim relief creates a bit of a practical problem. It says, it uses the word his own cell. It doesn't specify whether it's a single or a communal cell. If one has to weigh the relative weight of the risks, if an inmate has got access to the computer in a single cell, though the risk is there, it is less pronounced than if every prisoner who wants to study in a communal cell has access to a computer in the communal cell. So we have a qualm only to that extent as an interim measure.
So let me just understand that you say that if Mr. Ntuli is to find himself in medium C in a communal cell, then you have problems with an order that says he may have his personal computer, obviously without a modem and subject to inspection and so on.
Yes. If it's a communal cell, then it creates additional risks of.
Okay, well, can I try to understand what are those additional risks? The other inmates would use his computer to do what? They can't access the internet.
The physical part, the cable can.
Oh, I see the cable.
And even the instrument itself they can get into a quarrel and somebody bashes his head with the instrument. And also the risk of cell phones use and hotspotting becomes even more pronounced because now he's in close proximity with other inmates who are able to they can if they access illegally, they smuggle the cell phones. The connectivity and the closeness in a prison cell heightens the risk.
Yes.
Thank you, Justice.
Well, the question of charging the laptop can of course be overcome by an order that he must be charged, for example, in the computer center, and he can use it during those hours while it's being charged. But I hear you about the communal cell. Thank you, Mr. Nalani. Thank you, ADCJ. I'm done with my questions. Thank you.
Thank you.
Mr. Nalani, my questions have been covered by your debate with Justice Majid. I was also interested on why the prohibition is a legitimate or serves a legitimate government purpose. So I will not repeat what you debated with Justice Majid, but I'm still battling to find why the use of the laptop itself or the permission to use the laptop itself would pose the problems that you say it poses. Bearing in mind, for instance, you've referred to the fact that a laptop can be used to hit someone. Can't a cell phone be used to hit someone? You've also spoken about the use of a charger. A cell phone uses a charger as well. I just don't understand why laptops in themselves, because you've admitted in the papers that you've got a problem, and your problem centers around the smuggling of cell phones, and we live in an era of smartphones. A lot can be done through smartphones. So even though you've debated this with Justice Majid, my concerns still remain as to how the laptops themselves, without the use of cell phones, pose that threat or are a risk to security.
Justice Chikul, the cell phones are prohibited. So you can't even get permission to bring the cell phone into a cell, either a single or a communal cell.
Yes, I accept that. But in the papers, you accept that you've got a problem. In fact, in that annexure that you've attached to the papers, it is very clear that most prisoners are caught with cell phones. So your problem is smuggling of cell phones. I accept that. And I know that they are prohibited. But my question is more nuanced. I'm asking, why then do you prohibit the use of laptops?
The risk is the use of the two devices together. Laptops are generally allowed except in designated places. So there is no total ban on computers. The ban is on cell phones.
I'm going to keep on interrupting you, because you've had this debate to a certain extent with my brother Majid. So, when I interrupt you, I'm trying to clear my mind so that, I don't keep quiet and then I'm left, with certain issues hanging. So are you accepting that if you were to solve the problem with cell phones, there would be nothing, there would be no problem with allowing laptops in cells?
The physicality, and I'm talking especially in communal cells, the physicality, the instrument itself, and the court, that risk would not go away. Even if you manage to completely do away with illegal cell phones in the cells. So that risk will always remain in our submission. If
in the record, can you please help me with references where you have referred to the physicality, to the assaults with a charger, the assaults with a computer, and all of that? You've submitted today that part of the risk is assault with the charger and with the laptop. In the record, can you please refer me to where you deal with that?
It is not mentioned per se in the records, but as I've said earlier, during the debates in the SCA, the bench raised this as a possible security which we are asked to comment on. And so it is a self-evident risk. I accept it is not mentioned pertinently and pointedly in the records, but it remains a self-evident risk. It's like it's like bringing a sharp instrument in a cell.
So we should just accept that even though you had not mentioned it, that it is a risk.
Yes, Justice, could we say it's self-evidently risky. And so a prison official can even go to the extent of saying, I will not allow inmates to bring in toothbrushes into the cell because they use that as assault weapons. I'll hold the toothbrushes. In the morning when you brush it, I'll bring the toothbrushes and then take them away. It is a function which we submit should best be left to the management of the prison authorities.
Can I just ask Mr. Nalani, why was this evidence not in the papers? Because when I was preparing for this matter, I battled so much to find what these risks are, because the only risk that is mentioned in the papers is the one of hotspotting, and the emphasis is made on the connection between the cell phone and the laptop. Hence, my concerns were, why are we so emphasizing the use of cell phones, and yet in this matter, we're dealing with laptops? So now that you've said that in the record, this was not mentioned, is there any reason why this, there was, the prison authorities did not elaborate on why this self-evident risk was not mentioned at all in their papers?
Yes, just we accept it was not mentioned. And when the court was going through the records, they wouldn't have found it. I mean, that is correct. But we hide behind NICRO, which says that some of the evidence that might be lacking even on the record, it does not mean that because they are not mentioned pointedly on the record, that self-evident risk that somebody can strangle somebody with a cord in a cell phone. And so we would ask the court to bear with us on that point. Thank you, Justice.
I wonder whether we cannot make an inference that it was an afterthought and only arose or came to your mind when, as you say, it was asked by another judge in the Supreme Court of Appeal. But let me move on from that. That kind of abuse, can it not happen at the computer center? That is the physical abuse of the laptops and cell phone. And well, let me leave the cell phones because we're not dealing with that here. Can't prisoners attack each other using laptops or computers or desktops at the computer center?
In the computer center, there are monitoring by prison officials, because they are the ones, because every movement of a prisoner in the facility is monitored quite closely. Somebody would open the cell or the place where the hub is, and they watch over the prisoners. And when time goes, they say, time up, and they lead them back to their cells. The difference is that once the cell is locked, and then that's when the risk might happen, especially even at night, when the doors are locked. So the difference there is that in the hubs, there's security, there's monitoring. There's a note that it may be even that they do CCTV monitoring. So it is possible to monitor more closely than either in a communal or in a single cell. Thank you, Justice Chika.
All right. Lastly, Acting DCJ, is it fair then to say that you accept that the use of laptops in themselves without the hotspotting with a cell phone do not justify the prohibition. But, well, as the case was presented in your papers, but that from your evidence from the bar, we should then say that, well, even if it is not in the pleadings, there could be physical danger. But that in your papers, you did not make that case.
We accept we didn't make that point pointedly in the papers. And we addressed the issue of security. Yes, the emphasis was on the hotspotting, use of the cell phones together with the laptop. We accept that. But the risk remains a security risk.
Thanks a lot, Acting DCJ.
Thank you, Justice.
Chief. Any other questions, colleagues?
Just one or two from my side, Acting DCJ. Mr. Nalani, you would accept that the prohibition on the use of laptops in cells is a blanket prohibition, or perhaps what may be described as an absolute prohibition. Is that correct?
Yes, we accept. It's absolute. The policy says so.
Okay, now this court in a series of cases, including Arena Holdings and Johncom and Chipu, sort of set its face firmly against absolute prohibitions because they don't provide a space for an administrator, in this case the department, to even consider any exceptions. And I think of just two that may come to mind. So the respondents in their answering affidavit says that the DCS shall endeavor to make computer-based training centers available in each prison. But we can't say for sure that that exists. We have hundreds of prisons throughout the country. And so where there is no such center, there's no access to a computer at all. The policy doesn't provide for that eventuality. Secondly, an inmate may be transferred to a hospital, not a prison hospital, but a hospital outside a civilian hospital. Would they be entitled to have access to a laptop while in hospital because they won't have access to a CBT? The point I'm simply making is that there seems to be, in developing an absolute policy, no consideration given to circumstances where there could be a departure from such a policy. What do you have to say to that?
Justice Kolapen, if one looks at the policy as a whole, use of cell phone, of computers for study purposes, you have to apply. You must show that you have registered with a course which calls for the use of a computer for purposes of the course, not simply in aid of. Because if you see not to print, you can go to the hub as well. And so, because of the centrality of the risk, it seems that what the department did was to eliminate the risk as far as possible.
Sorry, Mr. Nalani, I think you have traversed this ground. My question is a more pointed one in that the policy doesn't permit of any exceptions. Notwithstanding what you may say is the risk, but it won't cover situations where there is no CBT center. It won't cover situations where someone has to go to hospital for a month or an extended period, would it? Because it's absolute.
It says it's absolute in the sense of the cell. And so if you go to a hospital, the example given by Justice Kolapen, on the strict wording of the policy, you won't be covered because you're not in a cell. But as far as the cell is concerned, I agree, yes, it is.
And so you'd be Okay, so you would be allowed to use it in a hospital with all the attendant risks that go with it then?
Well, there, the department, as it does in every case when they release a prisoner, either to court or to an outside place, they would take other measures, security measures. And if the measures, other security measures are so big that they might not even able to have you access to it, they might well say, no, we're not going to allow you to use it in that setting. Thank you, Justice.
Okay.
Thank you. Thank you, Justice Colapen. It looks like that. Oh, yes. Yes, Justice Theron. Yes, Justice Theron.
Mr. Mbalelhle. If my connection becomes poor, I will
Perhaps
turn
switch off your
my,
video,
video.
Justice Theron. Maybe your sound will improve. Yes, my sister.
Yes, I have. Thank you. Thank you, Deputy Chief Justice. Mr. Nalani, I'm also interested in the question of the risk, which you had discussed with Justice Majid and Justice Chikri as well. And if I can take you to paragraphs 31 and 32 of the ACA judgment, which we find in volume 6 at page 506.
Yes, Justice Theron.
The last paragraph of the last sentence in paragraph 31 says, the particular risk identified and relied upon by the appellant is that a personal computer, even without a modem, may be paired with a cell phone to secure access to the internet and email. And paragraph 32 refers, I think, to the discussion as well that you had with Justice Chikri. And then in the 5th line, it says, so the question is, how much additional risk comes about because of the access that certain prisoners would enjoy to personal computers in their cells? That is unanswered on the papers. And then the SCA says, because that is unanswered, it's fatal to the application. And do you, or does the applicant accept, Mr. Nalani, that it bears the onus in this regard?
Yes, Justice Theron, we accept we bear the onus. But if I may deal with the sentiments in the paragraph and the lines mentioned in the SCA, when we read this, and this is a point I'm making earlier, it seems to suggest that because the prison environment is infested with cell phones that are smuggled, therefore bringing a laptop into that infested environment doesn't make any difference anyway, because the risk is there. And we're saying, well, it's like pouring oil to the fire. And so the department says, we accept there are these risks, the smuggling infested environment. We will not bring additional risk by allowing personal computers into that infested environment. That's how we read that paragraph, Justice Theron.
Yes. And in a similar vein, the High Court judgment, I think it's at paragraph 27. I just don't have it, but we don't need to go there. Yeah. The High Court judgment says that no evidence that where computers were used in cells that there had been security breaches, and that this was just speculation. And I think in response to some of the questions earlier, or in your opening address, you said it's a possible risk.
Justice Theron.
What do you? Yeah. Yes, please continue.
All risks are graduated. They have got differences of gradation. Some are higher, some are less, but they remain risks. Any electronic device, including a personal computer, remains a risk that it can be used to breach security or be used nefariously, unlawful. And so if I may, if we use the word possible, it doesn't detract from the fact that the view that the department takes is that there is a risk, that they may be paired, that it may be, there might be access, they might be able to access sites, be able to use it in a nefarious way. The risk is there. Thank you, Justice.
And I think there's two parts to my next question. In the justification analysis that must be undertaken in terms of Section 36, one of the factors to be considered is whether there are less restrictive means. Has the applicant considered whether there are any ways, anything that can be done to mitigate the risk that it says the personal laptop or computer poses when it's used in the cells? And you didn't quite respond to the suggestion made by Justice Majid that, if I'm correct, that he put this, if the charger and the cord can be used to strangle somebody, perhaps, why the laptop then? There should be a rule that it should be charged in the common area or in the data center or not in the cell.
Justice Theron, on the papers, there is no appearance, must be upfront, that there's no appearance that the matter was dealt with pointedly to say that it was done in general terms, that the resources of the department, if we're able, we need some monitoring mechanisms, some cyber security tools to be able to eliminate or ameliorate the situation better. But as matters stand now, there is nothing which is readily possible or readily discernible to be a more obvious or a more preferable, less restrictive manner of dealing with the issue. And so they said, at the very least, let's put all the personal computers in a hub. The inmates will access that hub. But anything else, there's been no pointed and particular exploration on the papers, at least, about the specific.
Isn't that a difficulty then that the applicant faces in this matter? And it's the applicant who bears the onus to show that there are no other less restrictive measures available.
Of course, the applicants bear the onus to show there are no less restrictive means available. But on an approach of the matter at a practical level, it does not appear, if some less restriction means are more obvious than others, even on a practical common sense view, would say, well, you can maybe place a grabber outside and monitor even if that is obviously a less restrictive way. But the approach has been, let's give them access. We can't deal with the risk as of now when the computers are in the cells. And maybe technology will evolve, but as of now, there's nothing which.
Maybe Mr. Nalane, you can continue conferring during the tea break. Let us take the tea break until 11:30.
Thank you, DCJ.
Court will now adjourn until 11:30. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone and then rejoin with video and sound when the hearing recommences at 11:30. Should you exit, you may use the same link to rejoin the hearing.
Thank you. Yes, Mr. Kapula?
Thank you, Acting Deputy Chief Justice. Justices of the Constitutional Court, all justices and counsel are online.
Thank you. Mr. Nalane, you were conferring with your colleagues in response to Justice Thron's last question.
Thank you, DCJ. The question was about less restrictive means. And one of the issues that was raised was, would it not be possible, for instance, to charge the PC not in the cell, elsewhere, and then bring it back to the inmate who is in the cell, so that they would not need the use of the charging cord for that purpose. It has its own practical difficulties and might even result in the inmate not having access at certain points. If the laptop goes off just after the close off, they close the prison, they close it for the night, and then at 6 o'clock, the battery goes off. We're back to the point that he can't then use that cell phone until that PC, until prisons open the following day. So, but it's got its own logistical and practical difficulties, but it does not solve the problem that the PC is an electronic device which can be used for all manner of ways, in all manner of ways. So while it might ameliorate the charging cord, but it does not detract from the nature of an electronic device. Thank you, Justice.
Yes, yes. Mr. Nalani, is there no way, or has the applicant tried to have some supervision or access or inspection to the laptop? Could that be done perhaps on a bi-weekly basis or even on a monthly basis? Because surely the technicians would be able to see which sites have been accessed by the respondent. And if I remember correctly, even the prison, the cells have cameras which can be monitored from a CCTV, from a computer room as well. And has the applicant pursued that? Has it said that that is not possible? One of the steps to be taken to mitigate the risk of a security breach.
The issue has not been raised pointedly, but inspecting well, let's say Mr. Ntuli has the PC in his cell, and let's suppose it's a single cell. I am not certain if it would be possible to cyber check an incident where a crime has been committed on the cyber web, if you come monthly or bi-monthly, when the whole...
I'm sorry to interrupt you, Mr. Nalani. Yes, it's interesting to hear your perspective, but the answer really lies in, has the applicant tried that, and has the applicant said that that cannot work? And that's just one example of a measure that I'm proposing that could be less restrictive.
Justice Theron, we take the point that there may well be a number of other less restrictive ways. And the point which is made generally by the department is that some of these measures would need more investment, perhaps in technology, in resources, personnel, and as matters stand now, the most practicable way to deal with this unknown cyber risk is to not allow electronic devices, because otherwise they might as well allow cell phones.
Mr. Nalani?
Thank you.
Yes, Mr. Nalani, thank you. Can you refer me to the papers, please, where the applicant says there are less restrictive measures which it can put in place, but because of budgetary concerns, it's not able to implement those measures? And does it set out its budget restrictions?
I cannot refer, but let me, I'm not certain that the budgetary restrictions were mentioned as a matter of direct reference, but as far as the inspections and searchings, at page 98, volume 2, they say 14.5, there are various other incidents which have led to security breaches due to electronic devices. A copy of a report by security official is annexed as BMS3 detailing the various security breaches. 14.6, currently not a single inmate has the use of a laptop and/or desktop in their cell. However, with the current issues we are experiencing with cell phone/electronic devices, we ought to do what is necessary to prevent the inevitable of security breaches. And then 14.7, the applicant states that his laptop does not have a modem or internet access. However, with the manner in which cell phones are being smuggled and are being used, it cannot be ignored that inmates will have the means to access the internet on their computers via their cell phones and commit a series of crimes. But the important one about inspections is 14.8. I also take note that the applicant is willing to have his laptop searched and inspected on a regular basis. However, this will not be sufficient to combat the respondent's reservations on the security breaches that could be compromised. And it goes...
This doesn't, I'm sorry to interrupt you, doesn't answer my question, Mr. Nalani.
No, the answer...
You've said, in your submissions, the earlier question, you said the respondent acknowledges that there are less restrictive measures that can be imposed, but it doesn't, because of budgetary restrictions, it cannot impose those measures. So I was asking, where does that appear in the papers, please?
Yeah, it is not mentioned specifically on the papers, but I'm saying that these are some of the obvious practical issues which one would have to look at.
Yes, no, I take the point that you make, and you with reference to what's in volume 2, but it doesn't answer the question. And my question was simply a follow-up on the submission that you had made. You made the submission that the applicant acknowledges that there are less restrictive measures that can be imposed, but it cannot impose that due to budgetary constraints.
I accept the point that Justice Ron is making, and accept that the issue of budgets is not mentioned in so many ways as a constraint on but I'm saying as a matter of practicality and common sense, if one were, and Justice Ron was talking about monitoring and inspections, that if this can be done monthly or daily or whatever other resources, and I'm saying the logical progression of that is that one would have to invest in resources, either new equipment to do the inspections or hire experts to do that. So it's merely a question of the logical progression of that. But accept there's nothing on the papers which pointedly speak to financial resources.
Yes, I have just two more questions, Mr. Nalai. The one is a follow-up from what you discussed with Justice Colopin and about the blanket proposal, the blanket prohibition. Would it be possible or why can't this policy have a provision that says, in exceptional circumstances, an application for a personal laptop will be considered on a case basis? And we're dealing here particularly with an inmate who requires the laptop, not just for completion of assignments. And this is the tool, it's data processing. It's an essential tool to furthering his education. Wouldn't this be a prime example of where there should be some flexibility in the policy? And perhaps this also goes to one of the concerns that I possibly have with the order that's made by the Supreme Court of Appeal. Does it effectively mean that every inmate who wants to have access to a laptop for their study should have one, or should it be provided in exceptional cases like this one, and where a case is made out for the use of a laptop?
What we submit is that if one looks at the order about re-looking or looking at the policy, it's an attractive measure, except if one departs from the point that you may not restrict. If you restrict the access into the cells, that is unlawful, and go and look at other means of doing it. If the thrust of the policy discussions, and I'm sure these are things that must take place on a constant basis with all the stakeholders, if the thrust is go and re-look at the policy without prescribing the end outcome, that is something which would give everybody, JIX even wants to make submissions and suggestions. That is something which can possibly be looked at, but without prescribing the ultimate outcome. Thank you.
My last question, Mr. Nalani, relates to what appears at page 100 of the affidavit deposed to by Ms. Mbalenhle in volume 2. Paragraph 15.8. I was informed the applicant does not need the use of a laptop at all material times to complete his course. And then reference is made to the annexure at 128 to 129. The annexure V2 does not support the allegation in 15.8 unless I'm missing something.
Let me go there to page 128. Yes. Yes, so the point that my learned colleague says that yes, in fact, what 128 says, 129 says does not support does not absolutely support what Mr. Mbalenhle is saying. But
It doesn't support it at all, Mr. Nalani.
But one of the considerations is that Mbalenhle at least took the time to contact Oxbridge and find out precisely what the cost entails. And this is an understanding of 128 is simply confirmation that Mr. Ntuli is registered. 129 is a confirmation of the modules and when to submit his assignments. Office data processing, submit your assessments at any time. Office data processing 201, submit your assessments at any time. Office data processing, submit your assessments at any time. You'll be sent an SMS with the final grade for each assessment. If you do not receive an SMS 4 weeks after having sent an assignment, please contact the students department for assistance. If you are unsure about anything, kindly refer to your success study guides for all policies, procedures. But as I read this, it simply says you can submit at any time. But except it doesn't then say you don't need a laptop to complete his course. Then I'm referred to page 81, volume 1. Yes, this was part of the application of Mr. Ntuli. Request to receive a personal computer or laptop. This was from Oxbridge. I'm currently registered as a student with Oxbridge Academy, having studied number housed at A singles. And then at the end, against letter 30, Mr. Mokadile, please verify with this institution if this offender is studying with a need for a computer and bring this application back to this office. Yeah, so the general thrust here is that there were inquiries and understanding is that you can submit at any time. And then she understood it to say that she does not need, that Mr. Ntuli does not need a laptop at all material times for his course. What the letter...
I'm sorry, Mr. Nalani. For myself, I can't accept that. What you referred us to at page 81 of volume 1 is a request by the respondent to use his laptop. And the note that you've referred to by, I think it's Mr. Mogadile, that we don't know who that is, but from the context, it seems that this might be an official within the department of the applicant. And that official is requesting confirmation that the respondent needs his computer for the purposes of his studies. What you've referred us to at page 81 really doesn't answer my question. It doesn't take us further. What Ms. Mbalenhle was saying at page 100, she was saying, I have contacted Oxford. They said he does not require to have his computer at all times. And then she attaches a document which does not support what she says. So
Except
On my
our-
reading of the on my reading of the papers, there is nothing to support the averment made by Ms. Mbalenhle that the applicant only needs his laptop for submission of his assessments.
If one reads what 15.8 and accept the first point about 81, I was referred to a wrong page. I accept it's not. It doesn't make the point. What 100 says, page 15.8, Ms. Mbalenhle says she contacted them. She's not saying that the correspondence says that he does not need a laptop to submit, to use the laptop at all times in order to submit his assignments or work. She is merely saying, I annex here to my correspondence representative from Oxbridge Academy as BMS4. And of course, I mean, this BMS4 simply says he is registered with the institution. And then she says what she was informed. So there is not necessarily a...
Yes, that is hearsay. That is hearsay.
Justice,
and just let me finish, please, Mr. Nalani. That is hearsay. The impression that's created by the reference to the correspondence is that the correspondence would confirm that. Or maybe that's taking it too far. Let's just say that the correspondence, see, there was no issue that he was registered as a student with Oxbridge Academy. There was no disagreement that he's registered for the course for data processing. So there was really no need for that correspondence because that is not an issue in this matter. The course he's registered for is not an issue. So if we accept then that the deponent put up BMS4 to confirm what he's registered for, the first part of what the deponent says in 15.8 is not supported, it's hearsay, and this court cannot have regard to that.
Can I answer, Justice Theron?
Yes, please, Mr. Nawari.
Yes, thank you. Of course, one is reading an affidavit, and it can be read in a number of ways. And how I read it, it's my own reading of it, that she says, one, I was informed. She's not saying that I was informed through BMS4. She does not say precisely how she was informed, but she says I was informed that the applicant does not need to use of a laptop at all material times. And then in 15.6, she says at page 99, I took the liberty to contact Oxbridge Academy to inquire on what the submissions and its overall cost entails. And 15.8 is part of what she was doing during the contact. The attachment might be a drafting style from whoever drafted the affidavit. But of course, it doesn't say that he does not need the laptop at all times. But it doesn't negate that she contacted them. And she's
what she says
informed.
That remains, yes, that remains hearsay. Yes, that remains hearsay with of that. It remains hearsay, which this court cannot have regard to and should not have regard to. But I don't think we can take that any further. Thank you very much, Mr. Nalani. Thank you, Acting Deputy Chief Justice.
Thank you, Justice.
Thank you,
Mr. Nalani. I just want to, there are 2 points that I would like to raise with you. The first one relates to the complaint that the applicants make that the SCA failed to consider the issues of overcrowding and understaffing of prison officials. This is made by the National Commissioner in his affidavit at para 47 and 56, where in the, and it appears that he does accept that that evidence was not presented before the other courts. Now, if the evidence was not presented, on what basis would the court have made a finding of overcrowding and understaffing if no evidence was presented to the court?
Yes, Justice, and as I was debating with Justice Theron about resources and budgets, those were not necessarily pointedly mentioned before the High Court and before the SCA. And the Commissioner's statement about overcrowding might not be precise if it was not raised at the SCA. But what we'll submit is that this is part of the exercise practicality of common sense of looking at it. And earlier on, I also mentioned the issue of the communal cells as opposed to the single cells, that the risks are graduated and are more attenuated in a communal cell where there are more people and more inmates. But I do accept the point that the issue was not raised pointedly before the High Court and the SCA. Thank you.
And for the Commissioner to raise it here, why would we be, on what basis should we accept it where there is no application for the admission of new evidence?
We take the point, Commissioner. We take the point, Justice Mbalenhle.
And then do you accept that we are dealing with a small number of offenders who would have been registered as students, and those laptops of theirs would have been registered and be able to be searched by prison officials?
Yes, even with searching, and the affidavit makes it that there is some form of searches. And the department say, even with the best efforts of searching, especially for contraband, we find that every time the contraband is struggled, is successful smuggling. So it is not about the number of laptops or devices per se. It is about the risk.
What about the fact that these would be identifiable? The prison officials would know who is in possession of a laptop, who is registered as a student requiring a laptop. So what would be the problem insofar as supervising those particular offenders during the usage of their laptops?
The issue is that, one, with electronic devices, transactions and matters happen instantly. And that's where the risk lies.
But these are laptops without modems.
Well, the emphasis is on electronic devices. And so, as long as you have an electronic device in the system, which a PC is, and so the risk is always there. And that is why a total ban, at the very least at this stage, is what can only be done to mitigate the risk. It is not so much about the numbers, that if the numbers are smaller, the risk is lessened. Even one electronic device, even if you know the owner, if the risk happens, there's interference with the security network of the prison, the risk will have eventuated. Thank you, Justice.
Thank you, Ms. Nalani. Thank you, Acting Deputy Chief Justice.
Thank you, Mrs. Any other questions, colleagues? Thank you, Mr. Nalani. Yes, Ms. Hassim.
Thank you, DCJ.
May it please the court, Deputy Chief Justice, members of the court. Let me begin by saying that this matter comes to this court after several judgments in the High Court over the last 9 years, in which the impugned policy was found to have violated the rights of prisoners. As in those cases, Mr. Ntuli challenged the policy in the High Court successfully. And we have the judgment there from Acting Justice Matsamela, who found that the prohibition on the use of personal computers in single cells is inconsistent with the Constitution and unlawful. I, in my submissions to you this morning, will address 4 topics. The first is the factual background, the common cause facts, which are actually quite important in this matter. The second is that the policy violates the rights in the Constitution to further education, Section 29, and the right in Section 35 2E of the Constitution. Third, I will submit that those violations are not reasonable or justifiable. And finally, I'll address the question of separation of powers and the remedy. In addressing these topics, I will pay particular attention to the evidence before the court. Let me begin first with the factual background and the undisputed facts. These are firstly that
Ms. Hassim, I'll add 1 minute to your time. Do counsel know somebody by the name of Mbalenhle Ntlanzingema? Is that person part of your teams?
Not part of my team.
Acting Deputy Chief Justice, I'm instructed by my client that that individual is employed in their offices and is in fact part of the Judicial Inspectorate, and that would be why they're requesting access.
Or if anybody listening can make contact with them, may they please request them to join via our YouTube channel, please.
We'll do so. Thank you.
Thank you very much. Thank you very much. Yes, I'm sorry about that, Ms. Hassim. Thank you. You may continue.
So, thank you. Deputy Chief Justice, I was dealing with the undisputed facts. Firstly, Mr. Ntuli is an inmate currently at Leeuwkop Correctional Center. It's a medium C correctional center. He is confined to his cell for 17 hours and 45 minutes every day. He was previously enrolled at Oxbridge Academy for a course in data processing, and it was in the context of those studies that he initially brought the application. Prior to his transfer to Joburg Medium C, Johannesburg Medium C Correctional Center, he had been an inmate at Johannesburg Medium B Correctional Center. While he was there for almost 2 years, he was permitted the use of a personal computer in his single cell. He was only denied access to his personal computer in his cell when he was transferred from Medium B to Joburg Medium C. He's currently enrolled at an institution called the Academy of York for a course on safety and security management. He is currently housed in a single cell. He has a clean security and disciplinary record. And justices, I will add, it's a late instruction, but I have been instructed that in the course of the week prior to this hearing, the attorneys consulted with Mr. Ntuli, and he currently has access to his personal computer in his cell. And that is not on the papers. It's an instruction I received belatedly, and I don't rely on it for the purposes of the argument, but I am informing the court of that instruction. So for inmates such as Mr. Ntuli, and this has certainly been his case from the outset, that a computer is not just a tool for studying in general, but it's in fact, in his case, an object of study because of the nature of the courses that he undertook. And so for him, it was impossible to study sufficiently and effectively through any different medium. Because what he says in his founding affidavit, paragraph 11, is the following, and I quote, "I need the use of a personal computer in order to complete this course, since it is absolutely absurd that a course in data processing can be done on paper." There's no substantive response to this from the applicants. There's just a bare denial in the answering affidavit, paragraph 10.1 of the answering affidavit. What the SCA had to say about it was that as follows. The SCA said, Mr. Ntuli's affidavit makes clear that access to a computer is an essential requirement of computer studies and that this is not disputed. Mr. Ntuli also referred in his affidavit in the High Court to the positive effect of prison education programs on recidivism and the importance of education in reducing recidivism as espoused by the previous Minister of Correctional Services, Mr. Mbalenhle. This was correctly not denied by the applicants. In fact, the former minister's statement, full statement in relation to that policy of promoting education in correctional centers was cited by Justice Colopin in the Henny judgment, Henny versus Minister of Correctional Services. And this is to be found at paragraph 40 of the Henny judgment. And if I might just refer the court to precisely what the former minister said, he said the following: "Research shows there's an inverse relation between knowledge, culture, and crime. The greater the knowledge, culture, and access to education, the less the crime. It is for such reason that we have made education, skilling, and training of offenders compulsory at DCS. According to the Freedom Charter, imprisonment shall be only for serious crimes against the people and shall aim at re-education, not vengeance. Ex-offenders must be fully integrated into society. They must be able to meaningfully participate in the knowledge economies of the 21st century." Close quote. It's thus undisputed on the papers that for student inmates such as Mr. Ntuli, access to their personal computers is essential for undertaking their studies. 2, that the policy fails to accommodate the educational needs of those students. 3, that access to computers and electronic study provides benefits to students through lower costs and speed of access to materials and submission of assignments. And 4, that education is an important factor in reducing recidivism in inmates. Those are the undisputed facts. On the basis of those facts, we submit that the policy violates the right to further education in Section 29 of the Constitution and the right to conditions of detention consistent with human dignity, including access to reading material protected under Section 35(2)(e) of the Constitution. The SCA referred to the residuum principle, which goes back through a long line of cases, notable cases in the context of our particular history, in fact. But what the SCA says is that with the adoption of the Constitution, it's clear that all rights, the Constitution confers all rights on prisoners. All rights extended to all persons are also extended to prisoners, subject only to limitation that meets the requirement of the Constitution, and that would be Section 36. Deputy Chief Justice, in our heads, we deal with the violations of right to equality, dignity, principle of legality, etc., in some detail. I don't propose to repeat those arguments now. And in fact, as the SCA determined, we need not get there. The primary right is Section 29, and we would say read with Section 35(2)(e). This, of course, does not render the constitutional values of equality and dignity relevant, because those values give meaning to specific substantive constitutional rights. This is why the Constitution, through Section 39(1), enjoins courts, when interpreting the Bill of Rights, to promote those values, equality, human dignity, equality, and freedom. So we rely on Section 29 and 35 primarily. In finding that the prohibition in the policy is unconstitutional, the SCA confirmed that it is primarily on the basis of the right to further education. The appellants say, on the other hand, that this is the incorrect approach. I was a bit unsure today, listening to my learned friend, whether we are in agreement on the approach or not. Initially, I thought we weren't, and then I thought we were. But let me say this. If the approach of the appellants is that there isn't a violation of the right to further education, because Section 29(1)(b) only imposes a positive obligation on the state to progressively realize that right, and that the policy, commendably, is attempting to do so, and therefore there's no breach, then I would say this is the wrong approach to the inquiry. The approach is the content of the right. That's the correct starting point, which at one point I did think I heard my learned friend agree, that the correct starting point is the content of Section 29(1)(b), and whether there's an infringement of Mr. Ntuli's right to pursue his chosen course of study. In other words, while it's correct that the right to further education is not immediately realizable by the state, it's subject to progressive realization in the same way as the other socioeconomic rights are, housing and health. But that's not what this case concerns. It doesn't concern the positive obligations on the state. It concerns the negative obligation not to restrict students from effectively pursuing their studies, not to diminish their existing access to the right. The negative obligation is a duty that the state bears in relation to all rights, and that's by virtue of Section 7 of the Constitution. So we're dealing with the negative obligation of the state, and we're dealing with the content of the right to start off with. And the SCA has confirmed and upheld the earlier judgments of the High Court. Although the SCA does not allude to the Henny judgment, it confirms the reasoning in the Henny judgment in the High Court. At paragraph 20, the SCA judgment says that the right to further education is the following, and I quote, "The right of every person, at a minimum, to enjoy the freedom to enroll in a course of study for which they qualify, into which they have been selected and for which they have paid. They should then be able to pursue this course of study. The right may well have a richer content, but the negative freedom the right confers is to restrain the state from taking measures absent justification that restrict a person from taking these actions, close quote. As I said earlier, the right must be understood in relation to section 35(2)(e) of the Constitution. And there's a legislative framework that gives effect to section 35(2)(e). And that's to be found in part through the Correctional Services Act and the regulations that underpin the Correctional Services Act. And those regulations and the Correctional Services Act have been dealt with by the judgments to which we've commended the court. I'll just refer again to the judgment of Justice Colopin in Henny, where he confirmed that section 18.2 of the Correctional Services Act contemplates that the offender, and I'm reading from the Henny judgment, that the offender, upon obtaining reading material, whether from the library or from outside the correctional center, will proceed to use the reading material in his or her cell, and there should exist no differential regime between the reading material being in book form or electronic form. That's paragraph 33 of the Henny judgment. So what the court did there was took into consideration the fact that study methods and study material has changed considerably since the approval of this policy back in 2007. The court recognized that personal computers currently play and will continue to play an increasingly important role as a means of access to information. That, in fact, in the words of Justice Colopin, access to a personal computer by students become a necessity and not a privilege. And so by restricting access to personal computers, you limit the number, you limit the right of a prisoner to effectively pursue studies, because it potentially limits the number of subjects a student can take. It limits the time period within which a student can pursue their studies. And ultimately, that judgment concludes that the refusal of the applicants to permit access to laptop computers compromises the right, infringes the right to further education. So the applicants say that there are systems in place to use computers in the computer hub, the computer room, computer center, or to apply to use your own personal computer, but in the computer hub. And that computer hub is open about 5 to 6 hours a day, depending on which affidavit you read. This, the applicants say, is sufficient. They also claim that this is supported in the case of Mr. Ntuli by their own correspondence with Oxbridge Academy, where when the respondent was enrolled there. But as Justice Turon has already pointed out to my learned friend, there's no basis for this at all, for the submission that the access to the computer room is sufficient because Mr. Ntuli doesn't require constant use of the personal computer, of a computer, in order to complete his studies or to submit his assignments. I won't return to that. I think Justice Turon has already taken the court to the relevant parts of the record. Safe to say that Ms. Mbalenhle simply says that she communicated with Oxbridge Academy, that according to them, he does not require access to a personal computer beyond what is permitted. And then what is put to the court as evidence of this is a letter. And that letter is not a letter from Oxbridge to Ms. Mbalenhle. That letter is a letter from Oxbridge to the respondent. And all it is saying is that it confirms the registration of the respondent with Oxbridge Academy for those particular courses, and that it may be submitted at any time, his assignments. So there's absolutely no evidence whatsoever on the papers to support the claim that the computer hub suffices. So much of the facts, but it's also an approach, I submit with respect, Deputy Chief Justice. It's an approach that's premised on what Justice Hoekstra in the case of Minister of Justice versus Hofmeyr described as a parsimonious notion of prisoners' rights. It was an argument that failed in the Henny case, in the Pretorius case in the High Court, in the High Court in this matter, and it was also an argument that was unsuccessfully raised in the Supreme Court of Appeal. And we submit that the SCA, with respect, correctly held that it's no answer to contend that there's adequate provision being made to Mr. Ntuli to have access to a computer in the computer center. And specifically what the SCA said in this regard at paragraph 22 is the following: the right of a prisoner to pursue further education is not determined by what might suffice to pass his chosen course of study. Rather, the right is to pursue the course he has chosen. That entails using time that is otherwise uncommitted, whilst confined in his cell, to study, and to do so in a way that is effective, which in the case of Mr. Ntuli's computer course is with the use of a personal computer, close quote. So this right is what the SCA is saying is not constrained. It's not necessarily constrained by virtue of being an inmate, because the court says that it's not suggested that the idleness serves any particular punitive purpose. So there's no inquiry or justification for the court here that the 17 hours and 45 minutes serves some purpose that is a punitive purpose that requires idleness as opposed to study. In fact, as we know, it's quite the contrary. The Correctional Services policy, as articulated by the former minister and as articulated in this policy itself, is to ensure the access to education and rehabilitation. So Mr. Ntuli would have been able to pursue his studies more effectively with access to a computer. He says in his founding affidavit at paragraph 15 to 16 that the computer center is only available, it's open for about 5 hours, he says 5 hours, Monday to Friday, sometimes on weekends, never on a public holiday. He is outside of his cell for approximately 6 hours a day, during which time he is to have breakfast and lunch, shower, clean his cell, and do his laundry, amongst other things. He also says that the center is noisy and distracting to study. And finally, he says that the advantage of having access to his personal computer is the ability to read electronic versions of books, which he says are cheaper than hard copies. So the infringement of the right is abundantly clear from the facts. But the approach is also unreasonable because by the applicants in this matter, because it requires, it's not consistent with their own policy. It's not consistent with their own mandate. It requires prisoners to make a choice between studying, exercising, recreation, and time for family visits. So this justification, I'm specifically dealing with the justification of, well, there's a computer hub, it's there and it suffices. I say on the facts it doesn't suffice, but it also doesn't suffice because it's not reasonable in terms of their own mandate. And if one has regard to the United Nations standard minimum rules for treatment of prisoners, the UN standards, specifically Articles 77, 78, and 79, what the court will see is that those standards recognize the following: that provision must be made for further education of all prisoners, that recreational and cultural activities must be provided in all institutions for the benefit of mental and physical health of prisoners. And in Article 79, the standards say that special attention shall be paid to maintenance and improvement of relations between prisoner and his family. So the standards recognize the benefits of further education, recreational and cultural activities, and maintaining social relations with family. All of these combined provide better developmental opportunities and empower offenders for sustainable life after release. But the blanket prohibition results in restricting the use of computers to times which overlap with the time to be used for these other activities and opportunities for family visits and communication. And in so doing, it undermines the standards, the very standards from which this policy derives its mandate, which is the UN minimum standards. We submit that it's clear that there's a violation of the right to Section 29. The policy can only limit a right to the extent that it is justifiable in an open and democratic society. Instead of justifying, it imposes a blanket ban. And we submit that there are 4 High Court judgments that come to the same conclusion, including a judgment of the full bench and now the SCA. The applicants make scant effort at justifying the limitation. First of all, and this is now well established, the state bears the onus of justifying an infringement of constitutional rights under Section 36 of the Constitution. The transition to constitutional democracy signaled a legal regime that demands accountability, culture of justification. Rights may not be limited without justification. Where there is a policy that limits a right, the government is obliged to provide the court with sufficient information to enable the court to properly examine its purpose, and by so doing, assess the reasons for the limitation. And we've referred this court to Minister of Home Affairs versus Nicro in our heads of argument for that proposition in the context of prisoners' rights. So that's the obligation that rests upon the applicants, to provide the court with sufficient information. That's not what we have been ordered in this case. All we are told is that the purpose of the restriction, and we're told this in vague terms, is for security reasons. In the answering affidavit in the High Court, which, the little footnote here, was filed 9 months after the application was brought. So a 9-month delay between the application and the answering affidavit. What it did was simply deny that Mr. Ntuli is a registered student, or that he had applied to use a personal computer. And they said on that basis, it can't be said that his rights are violated and that the application is not competent. So there was nowhere in the answering affidavit any reference to security concerns at all. It was a pure, bold denial that Mr. Ntuli was even a registered student In the supplementary affidavit, after receiving the reply from Mr. Ntuli, Ms. Mbalenhle then retracts her denial on the basis, in her words, that it was an oversight. So the denial in the answering affidavit was made without Ms. Mbalenhle having taken the trouble to inquire as to the true facts. She had denied also that he had been permitted access to a computer in his single cell while at medium B. In the supplementary affidavit, she retracted the denial. So all of the denials were then retracted in the supplementary affidavit. And she conceded that he had been provided access in medium B. And then this is the first time we start to hear about security concerns. But again, Justices, I must pause here to say to the court that this type of response by the applicants and this type of litigation
you are well into your last minute, Ms. Hassim.
Thank you, Deputy Chief Justice. I'll speed up. And maybe I won't make too much of a point of this, but I do think it's important. This case is not on our papers, and I'd like to refer the court to Permanent Secretary, Department of Welfare, Eastern Cape Provincial Government versus Musa. I don't have the citation at hand, but I'll get it. It's paragraphs 14 and 15. And it's simply to say that there the SCA approved of the manner of litigation.
Your time is up. You have very comprehensive heads, which we have all read. Ms. Hassim?
Thank you, Deputy Chief Justice. If I may afford 2 minutes to just conclude then on the remedy, because that's all that remains. Well, actually, no, that's not all that remains, but I'm happy to deal with it in the course of questions, because in fact, what is, and then this is the point, the security concerns, is that the case evolves over time. So first, there's no case made at all about security concerns. Then a case is made in the supplementary affidavit in vague terms as to security concerns. And that is about the cell phones and hotspots. And then we have, for the first time in the application for leave to appeal before this court, a reference to charging cables. None of this is supported by evidence. Not only is it not supported by evidence, it's just speculation that my learned friend said that the court should just take judicial notice of. I just want to say one last thing, and it's because it's on the facts, that the respondent in this case, in the answering affidavit before this court, points out that, in fact, prisoners are entitled to have access to things like irons, televisions, and kettles in their cells. He himself has access to some of these items, and they too have charging cords and cables.
Even the 2 minutes is up. I'm not being unduly mean. In the future, it will get very difficult, as to when exactly one stops the clock. We must stop it here, please, Ms. Hassim.
I accept that. Thank you,
Thank you very much. Ms. Hassim, why is the policy a law of general application for purposes of Section 36(1)?
Thank you. I did note the question that was put to my learned friend. And, I would say that it's tempting to be opportunistic and take the question and play it to our advantage, because if it isn't, then the applicant's case is truly—
You don't have to go the two-stage process, yeah.
Right. But now I won't be tempted by that opportunity and say that it was accepted in the Supreme Court of Appeal on behalf of the respondent, that it's a law of general application, and that the basis for that was Section 134, subsection 2 of the Correctional Services Act. So there's 134, subsection 1, which deals with regulations that may be made under the Act, and then 134, subsection 2, referring to standing orders and rules that might be made under the Act. And the same approach should apply to the standing orders as would apply under 134.1 to regulations which is that it's delegated legislation and therefore a law of general application. And that's the approach that was taken. As to the reference to the Hugo case, it was left open in the majority, the question. But the approach taken by Justice Mohoro was that one shouldn't take...
I will not be technical about this. And then she said it is a law of general application.
Indeed, indeed. And that's the approach that we have accepted in the Supreme Court of Appeal and are therefore bound to accept before you.
Except that Matatiel and other cases say that you don't necessarily have to stick to a legal point if it may prove to have been wrong. And I'm not saying that your point is wrong, not at all. Yes.
It's certainly open to this court to make a conclusion because it's an objective legal determination. Ultimately.
Yes.
And what I would say to the court is that by virtue of having adopted the approach that the respondent has done, is that we've met the highest burden of making the case that not only is the right violated, but that it's not reasonable and justifiable.
All right. What other countries allow prison inmates to have laptops in their cells? I'm asking this well aware of our jurisprudence, which says that much as we can take into account what pertains in other jurisdictions, we should, however, never lose sight of the fact that we are here dealing with the South African Constitution and challenges under that Constitution. But that notwithstanding, I'm still interested to know what other countries have something of the nature advocated for by Mr. Ntuli. And please, I have read somewhere that one of the Scandinavian countries, their prisons are running empty because there's virtually no crime there. So please don't give me an example like that.
I'm afraid I don't have an example for you, Deputy Chief Justice. We haven't actually explored that on the papers or in our heads of argument. My learned friend for the Judicial Inspectorate might have an answer for you, but I'm not aware of a specific example where this where there's a policy
even though in their heads they too, because I was really looking forward to that, even though in their submissions they touch on, and I mean no insult by saying this, on more generalized provisions in the treaties and other international instruments they refer to. So it does not touch on this issue, but let's see what they will say. I'll move on to. Thank you, Mr. Asim. I'll move on to my last question, and it relates to the framing of problem, if it be a problem. The problem is stated as if there is something the matter with the use of computers in the hub, that automatically translates to use of computers in the cells. I have somewhat of a difficulty with that because I think the essence of the problem is the sufficiency of the time or lack of it. There is time for the use of computers for purposes of study. I would imagine that there should be no problem whatsoever if there could be no question about the sufficiency of the use of computers in the hub. I would not see why an inmate would want to insist on using their computer in their cell. if there's just no question whatsoever. And for purposes of my question, let's not get into the debate of, but what's the sufficient time? Let's just say there is no question whatsoever. So what would the problem be with the use of computers in the hub if there's no question at all about the sufficiency of the time? I'm asking this question thinking, for example, about this. The prison authorities, this is somewhat of a web, as it were. And the prison authorities are best placed to know what strings of the web to pull, what strings of the web to detach. They could even revisit the entire web insofar as it relates to, for example, what we are about here, and also even the general regulations with regard to the time or the length of time for which inmates may or must be locked up. They may say, let's reduce that time there so that we are able to increase the time for use in the hub and so on. So to cut a long story short, assuming that we are with Mr. Ntuli, would there be anything wrong with just saying this policy is unconstitutional to the extent that it does not afford inmates enough time to use computers? We can decide about the exact framing and so on. And perhaps for purposes of interim relief, we can have something that says in the interim, inmates must be allowed to use their computers in their cells. But we do not channel correctional services to a situation that says it is obligatory that they must provide for use in the cells and nowhere else. Or rather, there may be a combination of the hub, but plus, and that this is obligatory in the cells. So I'm saying, isn't there room for not necessarily channeling correctional authorities into that corner? For purposes of the main relief, the interim, yes, we may say in the interim, use the cells. What's wrong with that?
Justice Mhlanga, I'd have a problem with that because the approach is to say, what is sufficient time? And how do we determine what is sufficient time?
Can't we trust correctional authorities to decide that? There are several policies out there. There are several policies out there, not necessarily in this context, where the organs of state are left to take the policy decision. And the policy decision would relate even to the sufficiency of time. Whether or not it's sufficient, that's something that could be challenged down the line as well.
I hear the question, but again, the starting point is the ability to use it for the purpose, to use personal computers to pursue your studies effectively and for 35(2)(e) purposes, reading material, etc. So given the fact that prisoners are incarcerated for lengthy periods of time, I think it's a difficult question for this court to be able to answer. Well,
we will not be answering it. We will not be answering it. We will be leaving it to the correctional authorities to decide how to pull these various strings of the web or even detach some of them. We won't be, all we will be saying is, based on the evidence that we have been given here, the time available is simply insufficient. And for that reason, this policy is unconstitutional. So that goes to the insufficiency of the time, because that is exactly what Mr. Ntuli is saying. So he can't complain about a holding that says unconstitutional because the time is insufficient. That's his point exactly. And how the insufficiency automatically translates to use in the cell, that I do not understand.
Well, I suppose it comes from the facts of this case and from the other cases where this similar challenges were brought. So you know, the limitation here has to be justified. So what the applicants are saying is that it's justified because there's a risk to having it in the cell, but there's no basis for that. So to look for an answer that says, well, it doesn't have to be in the cell if you have sufficient time to use it in the computer room, doesn't deal with the fundamental problem that's before this court, which is what is the basis for limiting it in the first place to the computer hub? Because there's no evidence to show that having access to a personal computer in a cell is a risk of any sort. There's no evidence for that before the court. It's not been an evidence before any of the courts that have dealt with this since 2015. So that's the question. That's the question.
I'm not altogether sure about that. I think a point may be made, as indeed Mr. Mnalanhe did, that at the level of objective facts, if not judicial notice, I mean, there is a danger in the use of electronic devices in a prison. So one should not be overly strict and overly close one's eyes with regard to what, in my view, is the reality out there. And I quite understand Mr. Ntuli's point about the need to be afforded sufficient time. I am not insensitive to that. I'm quite sensitive and quite open to that. But what I just do not understand is the automatic fallback, which is that use in the cells if there's something wrong with the use in the hub.
So
who knows? It may well be that in the end, when they do what I've referred to as pulling strings, detaching strings, and so on, it may well be that in the end they will say, yes, the best option is to allow inmates to use their computers, personal computers, in the single cells.
Justice Mbalenhle, the difficulty I'm having with this line of question is that it's basically what it takes as a matter of, as my learned friend Mr. Mnalanhe refers to, common sense and judicial notice.
I will not refer to Mr. Bester's case. I will not go there at all.
I mean, let's not go there, because one could say a lot more about actually what happened. But the thing is that prisoners have had access to personal computers in their cells. In the case of Pretorius, they had access for 11 years. There was no security breach. Mr. Ntuli himself had access to a personal computer in the cells. There's no security breach. So that is actually the factual circumstance. That's
just like the vast majority of prisoners have toothbrushes and they don't sharpen them and use them as weapons. But that doesn't mean that there isn't a minority that does.
Well, there still needs to be evidence to show. You still need to be. You wouldn't deny. In fact, in the prison, the applicants here don't deny access even to things like kettles. So the point is, there's got to be a justification, and there has to be a reasonable application of the policy and a reasonable conceptualization of the policy, and it must be consistent with other policies. And there's just nothing before the court to say that in this case, for this particular device, not for irons and kettles and TVs, prisoners have access to that in their cells, but for this particular device, the one device that they can use to exercise their rights, to further education, a fundamental right, and for the purposes of rehabilitation and for integration upon leaving prisons, that in this particular case, there's going to be a different standard applied.
Thank you very much, Ms. Hassim. Colleagues?
Mr. Sim, just assist me. Can this policy be said to be rules and regulations which prescribe how prisoners conduct themselves in prison?
This policy, as I understand it, Justice Ntuli, is well, the policy is intended to give effect to access to further education. So to the extent that it includes rules as to how prisoners are to conduct themselves, it's within the context of accessing educational opportunities.
But the prohibition, does it not entail rules and regulations on how prisoners conduct themselves, in the sense that they cannot bring personal laptops in cells, but can use them in the computer hub?
Yes, I would agree with that.
I'm asking this because I would like you to disabuse me of the thinking that perhaps this case could be similar to what was said in August versus Electoral Commission. Because in that matter, this court acknowledged that prisoners are entitled to their basic rights, which I agree with. But the court then said that there are rules and regulations which prescribe how they conduct themselves and how they are to be treated whilst in prison. And it seems to me that whilst the court accepts that the prisoners are not deprived of their freedom, it acknowledges the right of the prison to have rules and regulations on how to conduct, on how prisoners conduct themselves in prison.
Absolutely. But what Justice Sachs said in August was that there are rules and regulations and there are appropriate restrictions on the way in which prisoners may conduct themselves, but that they are still entitled to their rights under the Constitution. So the rules and regulations, to the extent that they limit a right, must be reasonable and justifiable. So all rules and regulations within correctional services must be reasonable and justifiable. And that's where this policy fails, is that it violates a right, but without a proper justification. So it's not a, what Justice Sachs was referring to in August, and in fact what the SCA has referred to in other cases, Kwakwa referring to Kondwayo as well, is that there's nothing special about the prison context, which says that there's a different way in which rights are limited. Rights will be limited because of the incidence of being a prisoner, but it must still be done on a basis of justification. And that's not what this policy is based on.
So you are saying that it may well be a rule and regulation on conduct, but it is not justifiable.
It may be that particular clause of the prohibition in cells is a rule relating to conduct, but it is not justifiable.
Thanks a lot, Mr. Sim.
That's, yes, thank you.
Thank you, Acting DCJ. Ms. Hassan, the SCA seemed to have taken the view that in the case of Mr. Ntuli, access to a laptop, generally speaking, was part of the content of his right to further education. And they also appeared to have adopted a test that it will always be part of the content of that right where such access will benefit the student in his or her further education. So what would be the implications if this court accepted that conclusion? And I ask this in the following context. Its consequence would mean that this court would accept as a general proposition that where access to a laptop will benefit a student, it is then part of the essential content of the right. That's a very low bar to meet. And the consequence of that would be that every student studying within a correctional facility will be able to assert the right simply on the basis of meeting the very low threshold that it's of benefit. But secondly, and more importantly, even though this case doesn't deal with the duty of the state to take positive measures, but rather its duty not to take steps that infringe the right, would the consequence of such a holding not mean that this court has endorsed the position, generally speaking, that access to a laptop furthers the right to further education, and that the obligation on the state to progressively realize the right to further education, which is not an issue here, will then be asserted on the basis that this court has accepted unequivocally that the right to further education includes the right to access to a laptop. Do we need to think about those unintended consequences? It may not appear to be a problem in this case, given Mr. Ntuli's circumstances, but is there something that this court should be concerned about in terms of such a general proposition? Or would the order that the SCA has made that the department revisits the policy take care of that, but mindful that in doing so, the court has set the parameters, the SCA, within which that policy must be considered, and it must be considered in the context if there cannot be a blanket exclusion on the right to have. That was a bit of a long question, but at the heart of it is really the question of the content of the right and its consequences.
Justice Collipin, there's no question here of a positive obligation at all. What the SCA is saying is that to the extent that an inmate has access to a personal computer at his or her own cost and wishes to use it for the purposes of study and reading material, that right of the that prisoner's right to do so should not be diminished. It should not be infringed. It doesn't require the applicants to do more. There are many rights, and this is, remember now we're talking about the right to further education, and which is a socioeconomic right. Unlike the right to basic education, for example, where the courts have had to determine some essential content. It includes textbooks as an essential component. It includes access to furniture and desks. It includes safe toilets. The courts have had to determine that. In the context of that right, which is immediately realizable, that would be the implication on the state, that the determination of those components require the state to do more than it is doing. That doesn't apply in section 29(1)(b), because all we're concerned. Yes.
Okay. Sorry, I hear your point, Ms. Hassan, and I'm not saying that arises in this case, but I'm wanting to separate the determination of the essential content to the duty of the state to progressively realize as a general proposition. And my question is, if this court determines in these proceedings that the right to have access to a laptop is part of the essential content of the right, because we have to determine that to establish that there was an infringement, because if that's not part of the right, then taking it away cannot be an infringement. And so the point is, if we establish that as a general proposition, then surely it must be arguable next month that somebody could say, well, the Constitutional Court has established the right to access to a laptop is part of the essential content of the right to, it's not realizable here and now, but state, you must please provide a plan with regard to the reasonable measures you will take within your available resources to realize that right. This case was never argued on that basis, but I simply raised the concern whether that could be one of its unintended consequences.
The duty of progressive realization and reasonable measures is always qualified. It's always qualified. It's progressive realization within available resources. It would require measures that are reasonable, not the impossible. I don't think that we're discussing a risk here of unintended consequences. Again, because as with many socioeconomic rights, there are many people in the country who have access to more than others.
Sure. I accept that. I accept that, Ms. Hassan, and I accept that the state could always find the escape route, as it were, through reasonable measures and to available resources. But where it may not be able to find the excess route is that the content of the right would have been firmly established by this court, that the content of the right to further education includes the right to have access to a laptop. And that would include for prisoners, even though in this case they provide it for themselves. But that's what I'm simply looking forward to, if you follow where I'm coming from.
Yes, I understand.
Ms. Hassim, I'm sure it's a few seconds before 1 o'clock. Let us take the break now, and you may resume or rather respond at 1:30. Court adjourn.
Court will now adjourn until 13:30. Please note that during the adjournment, you are welcome to switch off your video and mute your microphone, and then rejoin with video and sound when the hearing recommences at 13:30. Should you exit, you may use the same link to rejoin the hearing.
Yes, Mr. Khapula.
Thank you, Acting Deputy Chief Justice, Justices of the Constitutional Court, all counsel and justices are online.
Thank you. I'm sure, Ms. Hassim, you'll have an even better response. Please respond.
Thank you, Acting Deputy Chief Justice. Justice Colopin's question to me was the concern about the content of the right and the definition. I'm alive to the concern that Justice Colopin is trying to convey, but the approach to the question must be one on the basis of principle. And that means that you cannot define the content of a right with reference to what the state's obligations may or may not be. Here, the right is, as determined by the SCA, to have access to a personal computer for the purposes of study where it's necessary for effective pursuit of the chosen course of study. It may well be that as a result of saying that that is part of the core content of the right, that any plan for progressive realization in relation to Section 29(1)(b) should include provision for access to computers in those circumstances. How and to what extent will depend on what is reasonable. That may well be, but that can't be the reason for the implication for state obligations is a separate inquiry from what the content is. In other words, to repeat what I said a moment ago, is you can't define the content by looking at it through the prism of what a state's obligations are.
Thank you, Ms. Hassim. So you accept that the consequence may well be that, leaving aside the obligations, that the consequence of judgment such as ours, if we should be with you and if we should uphold the SAA's finding, would be that the question of the content would then be settled. What the state's obligations may be may then depend on its resources, etc.
Indeed, but the question of what the scope of the right is will be settled, and the scope of the right must be determined on its own, as distinct.
And that will be settled for purposes of inmates who seek access to laptops, but it may also then be settled for those outside of correctional institutions, but in other educational institutions, because then it would be the content of the right, not so. That has been settled.
That I must agree with that, Justice Colopin. And we are also in a world where technology is moving very rapidly. And so it's not inconceivable that that would be the case. But again, it's separate from obligations. And the right here is crafted quite specifically in the context of this case. It's where it is required for the purposes of the chosen course of study.
Sure.
And also, it's the negative infringement.
Sure. And on the SCA's reasoning that content would be settled simply on the basis that access to a laptop would be of benefit to the student, not necessarily, but of benefit. Correct? Because that's the language the SCA has used. Yeah. Okay.
That's
thank you, Ms. Hassim, and thank you, Acting DCJ.
If I might follow up, Acting Deputy Chief Justice, very briefly. I can see that my connection is not very stable. If I can take you to the order, Ms. Hassim, that was made by the SCA, volume 6, page 508.
I'm there.
Paragraph 1, and really I think most of this you've covered with Justice Colopin. To the extent that the Policy Procedure Directive of Formal Education, as approved by the second respondent, prohibits the use of personal computers in cells, it is declared invalid and set aside. Doesn't it go too far? You know, we all know the dangers of the internet and even without a modem, virtual credit cards and what can be done and purchased. Surely it should be under certain, it should be allowed perhaps when necessary, and the policy can make provision for that. But to have a blanket order that a policy that prohibits the use of personal computers in cells is invalid, isn't that too wide? And not taking into the account the realities and safety and security concerns in prisons.
Justice Turon, the safety and security concerns have been put to us in a very speculative fashion. If we are talking about a laptop without a modem, a laptop that does not have access to the internet in any form, what would be the difference between that device and any other sort of just electronic reading device, or indeed even a book? In order for the court...
I'm sorry to interrupt you, Ms. Hassan, but I think the realities we know about cybercrime, we know, as I've just mentioned, virtual credit cards, data that can be sent, even without perhaps a modem. The data could possibly be sent during the time when the laptop is being used at the data center, and that data be activated at a later time when the inmate is in their cell, even if they don't have the modem.
Right, so there would have to be Wi-Fi capability, I suppose, then on the laptop. And this is why I think that the SCA order is not too wide, because it sets aside the policy on that basis, but it leaves it to the department to formulate a policy that can give proper effect to it. And in that policy, there may be any number of restrictions that can be placed upon the actual device that's used in the cells.
Yes, Ms. Hassan, but if you look at the order, it says a policy that prohibits the use of personal computers in cells. So are you saying it could limit the use on a reading of the SCA's order, that a policy that limits the use of computers or that regulates the use of computers in cells, that would be valid on a reading of the SCA's order?
Indeed, indeed. It is not open to, the meaning of paragraph 1 is not that personal laptops are permitted in cells without more.
Yes,
so
thank you very much.
Reasonable regulation through the policy that is going to be left to the applicants to determine.
Thank you, Ms. Hassan. Thank you, Acting Deputy Chief Justice.
Thank you, my sister. Any other questions, colleagues? Thank you very much, Ms. Hassim.
May it please the court.
Mr. Ferreira?
Acting Deputy Justices. Mindful of the role of the amicus, I will certainly not repeat any of the submissions that have already been made. We submit, with respect, Justices, that the case is really quite simple, and we propose to structure our submissions under the following headings. The first question that this court must answer is whether the policy that was set aside by the SCA limits the right to basic education. We will submit that it plainly is a limitation. And the second question, once it is clear that it limits the education right, is whether that limitation passes muster under Section 36 of the Bill of Rights. And again, we will submit evidence before you that it does not pass muster. If I may address the question of whether it is a limitation. The first point with respect, Justices, is what was debated between the court and our learned colleagues about whether the policy that was set aside is a law of general application. We submit with respect, Justice Mbalenhle, that this policy is a law of general application. It is slightly confusing because of the word policy, which appears at the top of it. In fact, that is misleading because I think, as was put by one of the justices to our colleagues, in substance, this is not a policy in the sense of an international trade policy that is made by ITAC, for example. In fact, it is rulemaking. It is rulemaking to generate rules which govern the conduct of prisoners within the jails of our prisons. And that is a classic example of delegated legislative administrative action. Justices, the distinction is well explained in this court's judgment in Minister of Education versus Harris, 2001, volume 4, the South African Law Reports 1297, a decision of the Constitutional Court. And in particular, at paragraph 9, this court explains the difference between policy and delegated legislation with reference to the SCA decision in the Akani Garden Route judgment. I won't read them to the court, but what was said by Justice Harms in Akani is that really the difference is between policy and delegated legislative action is that policy is not binding. Policy, while the CA decided not to define the word clearly, he says the obvious thing is that regulations and rules are legislative instruments, whereas policy determinations are not. As a matter of sound government, in order to bind the public, policy should normally be reflected in such instruments. In other words, policy determines the direction in which we are going, but delegated legislative action give effect to that policy by creating binding obligations. And in paragraph 11 of Harris, this court made that distinction plain. And so we submit that clearly the rules which are made by the National Commissioner pursuant to powers in section 134 brackets 2 of the Correctional Services Act. What he has done here in substance is make a rule. And that rule says that no prisoner may ever have a personal computer in their cell in any correctional center in South Africa. And that is clearly an exercise of delegated rulemaking. And so we say it is a law of general application, even though, as Ms. Hassan points out, it would be better for the position my client seeks to advance if it were not. But we submit that construed it is, and it would have to be, because otherwise the National Commissioner could never make rules pursuant to that power to limit fundamental rights, because the orders that he issues would never be law of general application, and so they would be incapable of justification under Section 36. And that would mean that it would be impossible for him to make rules which allow for him to administer the prison and impose this on prisoners, and in that way differentiate the rights that prisoners have from those which are had by people who are not in prison. The test really is whether it's been made is justifiable under Section 36. And Justice, there was a question about whether this was not, whether the August decision didn't dispose of this in the sense that it determined that this is just an instantiation of rules and regulations, and therefore it is permissible. We agree that August is applicable, Justices, but point out that August itself makes clear that where rules and regulations of this kind are implemented in the prison context, those rules and regulations are required to be reasonable and justifiable in terms of Section 36. Justice Sachs said that at paragraph 31 of the August decision, and it is even more clear by this court's decision in Necro. So this is, it clearly is law of general application. Submit to that it plainly limits the ability of prisoners' ability to pursue their right to further education. It's a limitation because on the common cause facts of this case, Mr. Ntuli requires the computer both as the of his study and as the medium through which he studies. So for Mr. Ntuli, not for every student, if you're a poetry student, you may be able to get your with an anthology in a printed book. But if you're a student studying data processing, if you are deprived of access to your computer for, I think it's 6 hours, for 17 hours and 15 minutes out of every 24, during that time, you are unable to yourself, and that is a limitation on your ability to fulfill your right of access to education.
You are left with just under 3 minutes, Mr. Ferreira.
Thank you, Deputy Chief Justice. If you read Justice Terrell's magnificent judgment in Sonke, it's clear from paragraphs 30 to 36 that this kind of limitation must be applied under Section 36 of the Constitution. And I won't read to the court from those paragraphs, but simply commend them to this court, where Justice on sets out the residuum principle and what it entails. So once you are in the world of Section 36, what follows? It follows from and August and Moise that there was an onus upon the minister to put up facts to justify the limitation. What were given in this case with respect was no evidence whatsoever in the answering affidavit of any incremental security risk entailed by computers. Once there is, you can already access the internet and commit all the bad crimes that Justice Theron is concerned about, and the computer itself doesn't add anything to that. And we say to all our learned friend, Mr. Nalane's speculation and giving evidence from the bar about people being throttled with extension cords and other security risks, the answer is very simple. The answer is that an absolute prohibition is unconstitutional, but that there must be a discretion which has to be exercised on the facts of each individual case which comes before the commissioner, which means that it does not mean that in every cell in South Africa is entitled as of constitutional right to have a laptop in their cell. It does mean that it is unlawful to have a blanket prohibition that nobody may have it. And this court has again and again said that when it comes to limitations of fundamental rights, a discretion to be exercised fully on the facts of each case is the safety valve which makes the limitation justifiable. And of course, this application might well be refused, because we know what Mr. Bester did the last time he got a laptop in cell, and so the National Commissioner might say, in this case, you are not entitled to a laptop even though you may be studying computer science, because we know that you're a security risk when you get a laptop in cell. But Mr. Ntuli, on the other hand, who is a model prisoner and used his laptop for studying computer science, to have a rule which says that Mr. Ntuli can never have a laptop in his cell, simply in order to accommodate the investors of this world, is one which is plainly overbroad and goes too far in our submission. Justice, that the approach to the evidence should be as set out in NICRA, where Justice Chaskelson looked at that was a case about limiting voting rights. Prisoners, the Electoral Commission came and put up evidence and said, we've got budgetary constraints, we've got capacity constraints, it would be infeasible for us to make voting stations in prisons, a much more extensive attempt at justification than you've got before you. And the NICRO court looked at that, scrutinized it, and said it's not good enough.
And right at that point, your time is up, Mr. Ferreira.
We've
read your submissions.
Thank you.
Thank you very much. Colleagues?
Mr. Ferreira, can I ask you, as the order reads, at the moment, the declarator in 3.1, to the extent that the policy prohibits the use of personal computers in cells, it is declared invalid and set aside. Now, two questions. The first is the one that Justice Theron raised with Ms. Hassim, is about the question of prohibits the use. As I understand it, your objection is against the absolute prohibition. Does that declarator convey that that sense that it's an absolute prohibition or not? And I'll come to the second part now.
Justice Majid, on the usual principles of interpreting court orders and the reasons given by courts, one must look at it in context. And in this circumstance, what is being referred to by Justice Unterhalter there is the particular prohibition which was challenged before him. So to what he is setting us look, and it's in the record at it's in volume 1 at 51. What he was setting aside there is the rule which says no computer shall be allowed, brackets, communal and / or single. That is what Justice Unterhalter declared invalid. And we submit, when you read the order in its context with regard to the particular rule that he set aside, it's clear that what was being set aside was the absolute blanket prohibition for all prisoners.
Thank you. Now, the second part is Mr. Nalane had some concerns about the words, the use of personal computers in cells. And he said that it may also include communal cells. And that creates an extra, as I understand him to say, an extra security risk as opposed to allowing a personal computer in a discretionary manner in a single cell. Any comment on that?
Yes, Justice. I just noticed that my video is turned off, and I apologize. It seems not to be on my end, but the host
I think the administrator did it because your sound was faltering and your connectivity isn't good. So I don't mind not seeing you, Mr. Ferreira, as long as I can hear you.
Thank you, Justice. Justice, yes, the comment on that submission is that the answer is the discretion. We don't say that every prisoner in every communal cell must be able to access a computer. We say that the head of the prison must have a discretion. If in that particular prison there are there's huge overcrowding and particularly dangerous computer hackers who've been in a big communal cell, and giving that communal cell access to a computer would cause a particular risk, then he may lawfully exercise his discretion to refuse a request when it's put to him. But this court, with respect, should not try to cater for every possible factual situation which might arise in the prison. What caters for that is a proper discretion exercised properly by the person running that prison on the facts in front of him, which he knows better than this court, and which this court, with respect, doesn't because of the inadequacy of the answering affidavit put up by the state respondents.
Yes, thank you. Thank you, ADCJ. Thank you, Mr. Ferreira.
Mr. Ferreira, can I just ask, building from your last answer to my colleague, Justice Majid, if you say there must be a discretion, presumably an order under section 134(2), which simply says that the commissioner may, in his or her discretion, allow the use of a PC in cell, would that not be impugned on the basis that it is too vague? Will the policy then need to, or the order in this instance, the order under section 134(2), need to spell out the relevant factors?
Justice Rogers, that is why we commended and asked Justice Unterhalter to require a new policy to be formulated after consultation with the Judicial Inspectorate, because we agree that a pure, unguided discretion is one that would be too vague, but we do not think that this court is in a position, based on the facts before it, to develop guidance that should be developed. And the proper place for that process to unfold is in the consultation between the Judicial Inspectorate and the state respondents responsible for running the commission. But we do agree that an empty discretion is no better guidance than, well, it is slightly better, but it's not much better than a blanket prohibition. And this court's decision in Darwood made expressly clear that where there are no appropriate guiding factors to guide the prison or the national commissioner in how to deal with these applications, that would potentially be void for vagueness and in itself give rise to constitutional difficulties.
If we were to uphold some form of interim arrangement during the suspension period, would we not necessarily be expressing at least some view as to how that discretion should be exercised? Because I assume you and certainly the present respondent would say that whatever the discretion is, it should cover the case of Mr. Ntuli. And if so, how would that be formulated? Would it be if an inmate reasonably requires access to a computer in his or her cell for educational purposes, would that, as it were, be one relevant guiding principle?
Yes, thank you, Justice Rogers. And with respect, we think that this is perhaps the one where Justice Unterhalter's order may go too far is in paragraph 6.2 of the interim relief, where it appears that that what is created in that paragraph is an entitlement to have a computer in the cell, provided you are registered for a course that requires a rather than a discretion, the exercise of a discretion. We accept that the factors that you put to us, Justice Rogers, are amongst the relevant factors, the need of the computer in order to fulfill the right to education. And of course, we would add that that particular security concerns may also be relevant factors to be considered during the interim period.
And this case has only been, mainly been concerned with the prohibition insofar as it bears on the right to education. I assume we should say nothing which would either grant or discourage the use of personal computers in cells where it may impact other rights. For example, I'm aware in other countries that prisoners have claimed the right to use a PC in their cells for creative purposes because they are writers or poets, or there might be other rights, whether it's expression, that are also restricted by a ban. So I can't recall, is the policy in the present case only concerned with the educational dimension? Because there may be other rights which would also be impacted by a refusal to allow a PC in a cell, not only education. Another has been, for example, the right of a prisoner to access and to study judicial material relating to his case, to prepare his defense. There are other rights that might be implicated by the ban as well. Are we only concerned with the policy insofar as it bears on education?
Justice, we would submit that you can decide the case based on the education right. It is sufficient to render this policy unlawful. I know that our learned friends for Mr. Ntuli have also pleaded their case, and their heads of argument rely on a wide range of other rights, including dignity and others. And we would agree that not foreclose that some different ban in different circumstances may be unlawful because it infringes a right other than education.
I'm not suggesting we should decide or even venture an opinion on how the ban might operate in respect of other fundamental rights. I think the Mr. Ntuli in this case used dignity in tandem with education rather than as a standalone right. But be that as it may, I'm just saying that there are other fundamental rights that may be affected by a ban, so that nothing we say should suggest that education, a right to education, should be the only circumstance which might reasonably justify the use of a laptop in a cell.
Yes, we agree.
Thank you.
Mr. Ferreira, it looks like those are the last questions. Thank you very much.
Thank you, Acting Chief Justice.
Thank you. Mr. Nalane?
Thank you. Thank you, Acting DCJ. There's one or 2 points. Maybe let me not enumerate the numbers. Yes. I might trip myself. The point raised by our learned friend for Mr. Ntuli, it was made, and my learned friend qualified as it says, it's not on the papers, but she mentioned it to say that Mr. Ntuli has access as we speak to his personal computer in his cell at local prison. It was on the back of other submissions made that in Pretorius, for instance, the inmates had access for 11 years. And even in the case of Mr. Ntuli, before he was moved to medium C, he had access to his laptop in his cell. And so the point, as we understand it, made is that there is no danger because as we speak now, he's got access and the heavens are not falling. So why insist on this ban? So dealing with that, on the papers, the department explained dealing with the medium B, medium C. On the papers, the department explained why in medium B he had access to the personal computer, but they make it clear that he shouldn't have had the official consent. Mr. Mahlangu had gone against the policy. And this is dealt with in volume 2 on page 89, 5.2. Prior to his transfer, the applicant alleged that he was permitted to utilize his laptop in his cell in medium B for study purposes. And then 5.8, it says, Mr. Mahlangu indicated that medium B did not have a computer room as the prison is an admission facility which is meant to accommodate sentenced inmates for a brief period in anticipation of them being classified in order to be transferred to the allocated facilities when they are to serve their sentence. And 5.9, however, due to overcrowding of prisoners, various facilities, it resulted in various prisoners remaining in the admission facility for longer period than intended. It does say it was an exception, but Mahlangu expressly says that he should not have allowed Mr. Ntuli to have the access because it was against the policy. But the fact that nothing happened, no breaches happened, doesn't mean that a blanket allowance of PCs must be allowed. It's not an either or. Because he has used it in medium B and there were no breaches, therefore he should be allowed to use it anyway. And in the present case, we took instructions during the break, and it's not on paper, but the instruction is that at Leeuwkop, he's not using the computer in his cell. He's using it in the hub. So although it doesn't have to be decided, but the point is that the impression that has been created is that even now he's using it in his cell, and therefore he must continue to be allowed to use it because there's no problem, then there are no risks. And we just wanted to make that point. And earlier we asked questions about the overcrowding that the commissioner raised in his application for leave to appeal, which was not raised in the lower courts or even in the SCA. But the point is that the department did mention overcrowding at some point in their papers. And so it is not something that the National Commissioner simply suck out. or just made it without any basis. The next point is the question that was put to our friends about if the issue is about time, why can't time be fixed? Even if Mr. Ntuli spends an extra 2 hours or extra 3 hours in the hub so that he can adequately deal with whatever he needs to deal. In the papers, it is clear that Ms. Mbalenhle said that she contacted the institution. So it is not outward, it is not impossible that the authorities can say to the institution, here are the modules that the prisoner has to do. How many hours do they need to spend on the computer? And that may then be the web that DCJ talked about. And so those are the range of issues that can be. And so it is not a question of simply because you don't have time, therefore, you must get your PC in your cell. It does not follow. And as far as the issue of the order, which was debated with another friend, Mr. Ferreira, indeed, even the interim order is couched in absolute terms. And the concern that another friend, Mr. Ferreira, raised is that a discretion of sorts should be allowed in the broader scheme of even formulating a policy. But the order itself does the opposite, because in the interim, there's no even room for discretion. If you study, you must be allowed. If you study and you need a PC, you must be allowed to use it in the cell without a modem. So it's the order is even in its interim form creates issues and sort of shortcuts the policy consideration of the main order which the Supreme Court of Appeals has made, that maybe go and relook at the policy. And of course, it might be a question of time, not necessarily the PC being used in the cells. I'm told I have 3 minutes unofficially. Let me see if there's any other point to that. And then Mr. Ferreira concedes that a PC can be a security risk in whatever form. And so the concerns of the department are not outlandish. They are real, they are practical, and they are real life concerns. Those are our submissions.
Thank you, Mr. Nalane. Something has just crossed my mind, and I would like to raise it with counsel. Justice Edwin Cameron, who heads the inspectorate at JICS, is in contact with me in the context of preparations for a memorial court session, which will be on the 22nd of November. That is a Friday next week. I thought I should mention that you never know, with these things, counsel might suddenly know that Justice Madlanga is in contact with Justice Edwin Cameron and raise issues around that. That's the only reason I am in contact with Justice Cameron. One, he is on the program. He is a speaker on the day. Two, he is the liaison between the court and the family of Justice Laurie, the late Justice Laurie Ackerman. That is the full context. Do counsel have any problems with that?
Well, from my side, none whatsoever.
The rest of counsel?
Justice Madlanga, appreciate you bringing it to our attention. We have absolutely no objection to contact between you and Justice Cameron in those circumstances. We have no apprehension at all.
Thank you very much. You would not possibly have any problem, Mr. Ferreira, I don't think.
Justice Madlanga, I think it is unfair that I'm the only counsel who has to contend with 10 Constitutional Court justices and the others only have 9. But other than
Thank you very much, counsel. Thank you for your submissions. Judgment is reserved. Court adjourned.
The court pleases.
Court pleases.
as the court pleases.
Today's proceedings have concluded. The host will now terminate the meeting.